morning. My name is Samiksha and I'm here to present a presentation. My student ID is NHE3094 and I'm here to speak about the duties of a director under Australian legal regime, Australian Securities and Investment Commission, ASIC versus Casimatis number 8, 2016 FCA 1023. And I'm going to talk about the general duties of the director. Now we'll start with the first duty, which is always acting in the best interests of the company. All actions should be proper and legally tenable. The director should always act carefully and diligently. No conflict of interest between the director and the company. I will continue with the other duties, which involve not to involve the company in any trade while the company has become insolvent. During the winding up of the company, the director should extend all the possible help to the liquidator. All such actions are governed by relevant Australian laws, notably the Corporations Act. The ASIC and the courts are always vigilant to ensure that the law is not breached. And the other topic will be continued with my friend.
Hi, good morning. My name is Rashika and my student ID is AZZ8035. Samiksha explained about the general duties of the director. I'm gonna continue with what is the conflict, what is the case study we have taken, and our case study is Australian Securities Investment Commission versus Casimatis. These two guys are a couple who started their company as a joint directors. The main intention of this company is a financial company. These two guys started their company, and these two guys are the stakeholders of their company. The main lead role for this company is to intake the financial services to the customers. Such it has model to severe losses. This model led to severe losses being affected by the investors during the global financial crisis. And the arguments against this consultancy is nothing but a Storm consultancy. The arguments against this Storm was the ASIC brought an action in 2010 based on inter alia regarding the following grounds. The director breached the section 180, which means providing such advice to the investors of Storm that breached the provisions of Corporation Act, acting in such a manner that was very detrimental to the interests of these financial investors, which led to their problematic situations. The director in particular breached the duty of good faith and reasonableness as imposed upon them under the law. And the next topic will be continued by Mr. Amrit.
I'm Amrit, my student ID is MI3042, and next point is argument against Storms. The ASIC brought on action Storm in 2010 based on the following grounds: that the director had breached section 180 by provided such advice to the investor of Storm that breached the provisions of the Corporation Act, acting in such a manner that was very detrimental to the interest of the investor of Storms. The directors in particular had breached the duty of good faith and responsibleness as imposed upon them under the law. Court stands on the issues. The Federal Court of Australia proceeded with the case based on the duties of director as under the Corporation Act and default with the case accordingly. The court was the view that a piecement of
Hi, this is Cyclone. My student ID is EGU3017. I just want to conclude about the issue and the case here. As my friends has discussed about the issue, the court has been They said that the court held the storm and acted pretty much and breached by the providing advices and financial clients across in the spectrum of the client claim, irrespective of the financial health and the concerned client. The other issue by the court was the court finally held that all the two directors of the storm did not proceed any infections. They could wish anyway, they liability simply and the premises. The big truth was that there was liability, nothing less. The issue in the judgment was whether the actual breach and needed to the factually constitute a breach and the directors of the storm. The court answered in the negative rejection of ASIC's the similar concern, whether the duties under 180 developed only or to company. The court answered that such the duties, though devolved only the company, the scope of such duty was wide enough to also include the general public. As a conclusion, the directors of the company may be held liable for the breach of the duties as soon as they break the law, even they have shareholders of such company. The position of IAC as the ultimate authority of overseeing investments and affairs